Hello everyone. Now, the next topic which we are going to discuss is legislation as the source of law. The term legislation is derived from the Latin word legis, which means law. So, legislation basically means making or setting a law. Legislation is a source of law which consists of the declaration of legal rules by competent authority. This has been given as a definition of legislation by Salmon. Legislation is laying down the legal rules by sovereign or subordinate legislator. Law that has its source in legislation may be most accurately termed as the enacted law, and all other forms are unenacted. We already know the process of making a legislation, and therefore, this can be the special attribute connected with legislation as an enacted law. The importance of legislation in the modern state system is of the paramount importance. It is the highest importance because of the concept of mandate, which is attributed to the democratic setup, wherein there is representatives are elected and they possess the mandate based upon the social contract theory, because of which the law making power, which is rested in the citizens, is transferred to the representatives. And because they have that mandate, when they decide something, it is as if the people have decided upon that thing, and therefore it is of highest importance. This is not just the only reason why it has become important. There are various other advantages which are there with reference to legislation, because of which it has become an important source of law. It is most authoritative and recognized. This is because of the various advantages which it has over the other sources. So, what are these advantages? So, let us compare the advantages of legislation over custom, and then we will compare the advantages of legislation over the precedents. So, the first is that advanced method of legal development and its characteristic of a matured legal system. We can say that legislation only can have this attribute. Customs are conversely important in the primitive society. Secondly, the existence of legislation is de jure because the authority, the mandate, which I already spoke about. Whereas customs, on contrary to that, the authority of the customs is basically de facto. The existence of the customs is basically de facto in nature. Thirdly, legislation embodies the will of the state, whereas custom embodies the will of the people. Fourthly, legislation is more superior and more authoritative than customs. Fifthly, legislation comes into existence at the instance of the state. State or a similar entity is a prerequisite of legislation. And now that we know that in the modern systems, it is not possible to create a non state entity or to maintain a non state entity, state as a creation is a mandatory aspect of political science, and therefore a mandatory aspect which every law student has to understand as a prerequisite. And therefore, because of the existence of state, the creation of authoritative legislation becomes easier with reference to a law making body, which is the legislature. On the contrary to that, customs describe the relationship between person to person. So, per se, there is no requirement of any state or any such other non state entity or even agency which is going to form any customs. Uh, we come to the advantages of legislation over precedents. So, basically, we need to compare the attributes of legislations with reference to precedents. First advantage which the legislation has is that it is more effective in changing what already exists. If at all we are interested in changing the society, because law applies in two ways with reference to the society, either law changes the society or law has to cater to the needs of the changing society. In either of the situations, legislation becomes an easier tool than precedent because of its abrogative and constitutive power. Secondly, it is more efficient. The moment it is created and it is published in the official gazette, it is deemed to be the law of the land, and every person is expected to know the law of the land, because of which it is efficient in nature. It is declared, and the moment it is declared, like I said, it is deemed to be a part of the law of the land, and every person has to abide by it, no matter even if he has read about it or not. But the same does not apply to precedent, because with reference to precedent, case to case approach is more used and more applied. It is more direct, legislation is more direct, it is more unambiguous, it has greater access and reliability, and it is concise and definite. There is no 200 pages, 300 pages single judgment or 1000 pages judgments running. This is not the case with reference to a precedent. It is more precise, it can be understood, if not understood, at least read by people who are non law background people. The same does not apply with precedents, because precedents are more technical and more complicated to understand. However, this does not mean that legislation is the most important and the best source of law, because everything cannot be generalized. Because legislations are most of the times with reference to generalizations. They don't imply or they don't focus upon the individual problems or the inefficiencies which would apply or which would come up because of the individual problems. Such problems are catered and handled by the judiciary in the precedents, or by the executive in the application of the process. In either of the ways, law has this disadvantage because it cannot cater to this special individual requirement. The second disadvantage of law is that for unforeseen situations, law cannot have an answer. Like, for example, the current situation which we are going through, the lockdown because of the COVID 19, uh, no one had perceived about it. Otherwise, there were rules with reference to ending of the economic year, as they call it, the financial year. There were rules with reference to conduct of examinations, and there were so many other rules which had been laid down by concerned authorities, which gave them the status as of a legislation, a subordinate legislation, but yet a legislation. They are not able to be complied with in such a scenario. So, unforeseen situations remain outside the purview of legislation. Legislations are too rigid. They don't change as per the requirement of law, as per the requirement of the state, as per the requirement of the changing society. And therefore, it becomes a little monotonous, a little arbitrary certain times to apply the law because of its rigidity. Sometimes the legislation can be worded in archaic language, and therefore it can be very cumbersome to understand. Try opening any technical legislation and try understanding what is exactly meant by the sections which are given in it. It is even difficult for the law persons to understand. Forget, don't even think about the common persons. And then it is expected that they should know the law of the land, and it is really a very cumbersome process. The next disadvantage can be the poorly drafted or badly written codes. Because of the loopholes, and this is something which is always found, that the loopholes are misused by people, by miscreants in the society. The legislation also has a disadvantage of being incoherent and defective in nature. So, for example, when there is a causes omissus which is found out by the judiciary, yet it cannot do certain changes, amendments in the legislation because it is not having the authority, can be few of the many problems which can happen because of incoherent and defective writing of the legislation. Lastly, due to codification of existing due to codification, the existing rights and duties, the customary rights and duties which have been established are disturbed. Now, sometimes it is a necessity, the state wants to change these, but sometimes it may not be even thought about when the legislation was being made. And therefore, if the exceptions are not drawn in, such rights and duties which were existing and which were peacefully coexisting at the time in different places, they get hampered, and therefore we cannot say that legislation is always having only a positive side and no defects or no disadvantages. We move to the next part, and that is the kinds of legislation. So uh, there are basically two kinds of legislation. There is a supreme legislation and a subordinate legislation. In the subordinate legislation, there is a little bit of a up down issue in the slide. The direct and indirect legislation are the two types of subordinate legislations. The supreme legislation is the supreme law of the land, whereas subordinate legislations are all the legislations which are not done by the legislative body. So there can be different categories of these subordinate legislations. Colonial legislation, which India was having before independence. So certain legislations were made by the lawmakers sitting in India, but because India was a colony, the legislation was having a subordinate authority. This is the only direct type of legislation which is there in subordinate legislation. Rest all are indirect forms of legislation. So executive legislation, wherein like the rules which are framed by the administrative authorities for their own functioning, let us say, or the judicial legislation, which means the making of rules of their own for their own procedures which the judiciary has. And please remember, judicial legislation and precedent are two different topics. Don't get confused with judicial legislation. Precedent is something which is a different aspect, not the kinds of legislation in which we are seeing the judicial legislation at. Then there is municipal legislation, the legislations which happen at the municipal level. The autonomous legislations, or the legislations which are created by autonomous bodies. And there is delegated legislation. So delegated legislation is a law which is made based upon the parent act, which is the legislation, the parent legislation created by the legislators, and the authority which is given under it to a particular appropriate government, as generally the wordings say. And whatever legislations are made, there are certain controls over it. There is a legislative control over it, there is a judicial control over it, and all of that is a part and parcel of the subject matter of administrative law. So these are the different kinds of legislations. Coming to the base of legislation, and that is codification. So, code means a systematic collection of statutes, a body of laws so arranged as to avoid inconsistency and overlapping. Currently, in India, there is a process of labor code which is going on. So, I would suggest you to kindly refer to this labor codes which are coming into existence and go through them and find out the comparison between the existing labor laws, the enactments, and the different four codes which are being currently discussed. Then there are steps of codification are compilation, promulgation, collection, and systematization of the body of law in a coherent form by an authority in the state competent to do so. Salmon says that codification is the reduction of the whole corpus juris so far as practicable in the form of enacted law. Bentham says that a complete digest as such is the first rule. Whatever is not in the code ought not be law. So there are a few conditions of codifications which have been put forth by Roscoe Pound. Where legal institutions have become completely mature and where the country has no juristic post, the non-existence of such material is uh, im- not I mean it's not possible. There should not be uncertainty and archaic character of the law. There has to be development of an efficient organ of legislation, and the needs of one uniform law in a political community whose several subdivisions has developed or received divergent local laws. These are the four conditions of codification. There is If these are prevalent, then it means that codification is required, it's necessary. We can classify codes into three categories. The differences are actually only two, but the categorizations become three. First is a creative code. Okay, so from scratch, when nothing is there, um, what comes for the first time without any reference to any other law, that becomes a creative code. Whereas there is the other categorization, that is a consolidating code, where a code consolidates the whole statutory, customary and precedent, or uh, uh, in a particular subject, and describes it. Okay, so certain things which are already prevalent, if that is codified, then that becomes a consolidating code. And third category is a creative and consolidating code, when a few things were available and a few things were newly created. So with this, we come to the summary of this topic: legislation as a source of law. We saw the meaning and the importance. We saw the advantages of legislation as a source of law over customs as well as over precedents. Sorry, we saw the disadvantages of legislation. We also saw the kinds of legislations: supreme and subordinate. And in subordinate, there is a further classification of colonial, executive, delegated, judicial, municipal, autonomous. And then we came to the codification part of it. I hope you have understood this concept of legislation as a source of law. All the best, and thank you very much.